The tow truck driver was already hooking chains onto my wheelchair transport van when I pulled into the neighborhood. At first, I thought it had to be a mistake. Then I saw Denise, standing there in her white blazer beside the HOA entrance sign, with her arms crossed and that smug little smile she always wore whenever she thought she'd won. My mother's oxygen equipment was still inside that van. So was her mobility lift, and the custom medical ramp that cost me almost $12,000. I jumped out of my truck yelling for the driver to stop, but Denise stepped forward holding a clipboard like she owned the entire city. "You were warned," she said calmly. "Commercial vehicles are prohibited in luxury heights." I stared at her in disbelief. "That's not commercial. It's a registered medical transport." She shrugged. "It lowers property values." Then she nodded at the tow driver. "Take it." What Denise didn't know was that my cousin happened to be a federal judge, and 6 hours later, she'd be sitting in court trying to explain why she interfered with federally protected medical transportation. That was the day the HOA lost everything. My name's Caleb Turner. I'm 38 years old, and for the last 4 years, my life has revolved around taking care of my mother. After a severe stroke, she lost most mobility on her left side. She couldn't drive anymore, couldn't climb stairs, couldn't even get into a normal car safely. So I sold my old contracting business and moved back into the family house to take care of her full time. The transport van became our lifeline. It wasn't fancy. White Ford chassis, wheelchair lift on the side, medical decals, special rear suspension, custom oxygen mounts. Everything inside that vehicle existed for one reason: keeping my mother alive. Luxury Heights hated it immediately. The neighborhood was full of people obsessed with appearances, perfect lawns, matching mailboxes, no basketball hoops visible after sunset. The kind of neighborhood where people smile at your face while filing complaints behind your back. And leading all of them was Denise Hallbrook, HOA president, self-appointed queen of suburban perfection. Denise believed the medical van looked institutional. According to her, it damaged the luxury atmosphere of the neighborhood. At first, she tried small things: violation notices, parking warnings, letters about commercial equipment visibility. I ignored them because legally she had no authority. Federal disability protections overrule HOA aesthetics every single time. But Denise wasn't used to hearing no. One afternoon, she actually knocked on my door carrying printed photos of the van parked in my driveway. "You need to store it elsewhere," she said. I laughed. "My mother uses that van daily." "That's unfortunate," Denise replied, "but the community has standards." Standards. That word became her obsession. 1 week later, she sent another violation notice threatening fines, then another, then another. I stopped opening them. That's when she escalated. 3 months later, my mother had a pulmonary emergency. Her oxygen levels crashed around 2 a.m. I got her stabilized enough for transport and rushed outside to load her into the van. Except, the van was gone. At first, I genuinely thought it had been stolen. Then I saw the bright orange sticker on the curb, "Towed by authority of Luxury Heights HOA." I felt physically sick. My mother was struggling to breathe inside the house while I stood staring at an empty driveway. I called the tow company immediately. The guy answered, half asleep. "Yeah, we got it." "Where?" "Impound lot." "That van contains medical equipment." "Talk to the HOA." I have never driven faster in my life. When I reached the impound yard, they refused to release it without HOA authorization. Meanwhile, my mother's condition kept worsening. Eventually, paramedics had to transport her by ambulance instead. The ER doctor later told me something I'll never forget. If she'd arrived much later, this could have gone differently. That sentence nearly broke me. Not because of fear, because of rage. The next morning, I marched straight into the HOA office. Denise was drinking coffee behind the desk like nothing happened. "You towed a federally registered medical vehicle." She barely looked up. "You accumulated multiple violations. My mother could have died." Denise sighed dramatically. Mr. Turner, emotional exaggeration doesn't change community rules. I leaned over her desk. That van is protected under federal disability law. Then Denise smiled, one of those arrogant smiles people wear right before destroying themselves. Then sue me. Big mistake. Huge. Because most people didn't know something important about my family. My cousin Andrew Turner wasn't just an attorney, he was a federal district judge. And when he heard what happened, he got very quiet. That scared me more than if he'd started yelling. "You have documentation?" he asked. "Oh yeah." "Good." Pause. "Don't talk to the HOA anymore." That was the moment Denise stopped dealing with a tired caregiver and started dealing with federal law. Andrew connected me with disability rights attorneys before sunrise the next day. Within hours, they started collecting evidence: tow records, HOA violation notices, medical registration paperwork, security footage, emails, everything. Turns out, Denise had made a catastrophic mistake. Actually, several catastrophic mistakes. First, the van was federally classified as a medically necessary mobility transport vehicle. Second, HOAs cannot selectively enforce parking rules against disability accommodations. Third, Denise had ignored written notices from my attorney months earlier explaining exactly that. But the worst part? She put everything in writing. One email became the centerpiece of the entire case. In it, Denise wrote, "The neighborhood should not be forced to look at medical vehicles every day because one resident refuses alternative arrangements." The attorney literally laughed reading it. Then came another email. This one was worse. "Exceptions create weakness in HOA enforcement consistency." That sentence basically turned our lawsuit into a nuclear missile. Because federal disability law absolutely destroys organizations that punish disabled accommodations for aesthetic reasons. And Denise kept digging deeper. When attorneys requested HOA internal communications, several board members panicked immediately. Turns out Denise had pressured the board into approving aggressive enforcement specifically targeting my van. One board member even admitted during deposition, she said if we let one ugly vehicle stay, more people would start bending the rules. Ugly vehicle. They were talking about the transport van keeping my mother alive. That statement alone made one attorney whisper, "Oh, this jury would destroy them." But Andrew had another idea. He wasn't interested in damages yet. He wanted immediate action. And because the transport disruption affected ongoing medical access, he requested an emergency federal injunction. That's when the HOA finally realized they weren't dealing with neighborhood drama anymore. They were walking into federal court. The hearing happened fast, very fast. Federal judges don't play around when disability access becomes endangered, especially involving medical transport. The courtroom was packed. HOA attorneys, board members, residents, even local reporters showed up after hearing rumors about a discrimination lawsuit. Denise arrived wearing a cream-colored suit and fake confidence. She still thought this was about parking. Then the hearing began. Our attorney opened with one sentence. The defendants knowingly interfered with medically necessary transportation for a disabled stroke patient. Everything changed after that. The judge immediately started asking questions. Was the vehicle medically registered? Yes, Your Honor. Did defendants receive notice of disability accommodation requirements? Yes. Did they proceed anyway? Yes. Then came the security footage. The courtroom watched Denise personally supervising the tow while my mother's wheelchair ramp sat visibly attached to the vehicle. The judge's expression hardened immediately. Then our attorney presented the medical timeline, showing my mother required emergency hospital treatment shortly afterward. You could feel the room shift. Suddenly, this wasn't an HOA dispute anymore. This was dangerous. Then Denise made the biggest mistake of her life. She interrupted her own attorney. We were protecting community standards. The judge slowly removed his glasses. "I'm sorry," he said. "Did you just say community standards?" Denise nodded nervously. And that's when the judge absolutely buried her. Federal disability protections are not optional, because you dislike how a medical vehicle appears. Silence. Then he continued, "The court is deeply disturbed by the apparent intentional targeting of a disabled resident." Denise looked stunned, but the real destruction came next. Our attorney introduced Denise's emails. Every sentence sounded worse out loud. Ugly vehicle, weakness in enforcement, neighborhood appearance. The judge read them silently for several seconds. Then he asked the HOA attorney, "Counselor, are your clients attempting to argue these statements are not discriminatory?" The poor attorney looked like he wanted to evaporate. At that point, even HOA board members stopped making eye contact with Denise. Then the ruling came. The federal injunction was granted immediately, and it was brutal. The court order hit luxury heights like a grenade. Effective immediately, the HOA could not interfere with any medically necessary vehicle. All fines against me were voided. The HOA was prohibited from future discriminatory enforcement actions. Denise and the board were ordered to preserve all communications for federal review. Additional civil rights penalties remained possible. But then came the line that changed everything. The judge stated there was probable cause suggesting intentional disability discrimination. That sentence terrified everyone, because now the HOA's insurance company got involved. And insurance companies hate one thing more than lawsuits: federal discrimination lawsuits. Within 48 hours, the HOA insurer sent investigators. Board members started panicking. Residents began demanding emergency meetings. Property owners were furious after learning legal costs might exceed $2 million. Then local news picked up the story, and Denise became internet famous overnight. Headlines exploded everywhere. HOA accused of targeting disabled resident. Medical transport towed during emergency. Federal judge issues injunction against HOA. People online absolutely shredded luxury heights, especially after reporters obtained Denise's emails. One news segment interviewed disability advocates who called the case one of the clearest examples of HOA discrimination in years. That destroyed public perception instantly. Residents who once supported Denise suddenly turned on her hard, because now their property values were attached to a federal civil rights scandal. One homeowner reportedly screamed during a board meeting, "You towed a disabled woman's transport van because it looked ugly?" Another demanded Denise resign immediately. Meanwhile, the board tried desperately to shift blame. But Denise had controlled everything personally. Every violation, every tow authorization, every threatening letter, all signed by her. Then came the financial disaster. The HOA's attorneys privately warned them the case could spiral into federal penalties, punitive damages, emotional distress claims, disability discrimination settlements, attorney fee reimbursement. Potentially millions, all because Denise couldn't tolerate looking at a wheelchair van. The board entered full survival mode. That's when they requested mediation. The mediation took place downtown inside a massive law office overlooking the city. By then, Denise looked exhausted. No more smug confidence, no more superiority, just stress. The HOA board sat across from us looking terrified, because now they understood something important. I wasn't bluffing. And federal judges really hate discrimination cases involving medical access. Their attorney opened carefully. "My clients wish to resolve this matter privately." Andrew folded his hands calmly. "My cousin almost lost his mother because your client prioritized aesthetics over disability law." Silence. Then negotiations began. The HOA's first settlement offer was insulting. Our attorneys rejected it instantly. The second offer was better, still rejected. Then Andrew leaned forward. "Here are our terms." He slid paperwork across the table. The demands included full public apology, permanent disability accommodation protections within HOA bylaws, complete reimbursement for legal costs, financial damages, mandatory fair housing compliance training, federal monitoring period. Then came the final condition. Denise Holbrook must resign immediately from all HOA authority. Denise snapped instantly. "This is ridiculous." Andrew looked directly at her. You interfered with federally protected medical transport. She tried arguing, tried blaming attorneys, tried blaming the board. But nobody defended her anymore, not even her own side. Because deep down, everyone knew she caused this disaster herself. Then Andrew delivered the line that ended the meeting. If this proceeds to trial, your emails become national news permanently. That broke her. You could literally see it happen. The realization, the humiliation, the fear. 3 days later, the HOA accepted every condition, every single one. Denise resigned before the next board meeting, and residents applauded when it happened, actually applauded. That's how badly she destroyed community trust. The neighborhood changed after that, completely. Suddenly, people who ignored my mother for years started helping. Residents brought meals, flowers, cards. Several apologized personally. One older veteran even came by and said, "My wife used a medical van before she passed. What they did was wrong." That meant more to me than the settlement money ever did. The HOA also installed new accessibility policies across the neighborhood, reserved emergency parking, medical accommodation protections, fair housing education. Ironically, Denise's attempt to remove one disabled vehicle ended up permanently expanding disability protections for everyone. As for my mother, she's doing better now. Still struggles some days. But every morning when I help her into that van, I remember something important. People like Denise think power means controlling others. But real power is protecting people who can't fight alone anymore. And if there's one thing I learned through all this, never underestimate how fast arrogance collapses once federal law enters the room, especially when someone mistakes disability accommodations for cosmetic problems. Because that tow truck cost Denise her position, her reputation, and almost the entire HOA, all because she couldn't tolerate seeing a medical transport van in her perfect little neighborhood. Turns out federal judges care a lot more about civil rights than HOA curb appeal. If you enjoyed this HOA revenge story, comment below. What's the craziest HOA abuse of power you've ever seen? And don't forget to like, subscribe, and turn on notifications for more stories where entitled HOA Karens finally get what's coming to them.